All right, I think we're ready to go. So good morning and welcome to Anchin's mid-year legal update, tailored strategies for law firm success. My name is Deb DeBreeze and I am partner and co-leader of Anchin's law firm group. Today I'm joined with Steve Lando, who is my co-leader, along with Tina Alcantine and Paul Gregory, who round out our leadership team. So during today's presentation, you'll notice that Tina and I will really tackle the attest or financial statement items, since that's the side of the firm that we really focus on. And then Paul and Steve will take anything that really relates to from a tax perspective. So before we begin, we have a few housekeeping items. The webinar will be 1 hour. There'll be 45 minutes of content and 10 minutes at the end of the presentation for your questions. The webinar will be recorded, and then we will distribute it via email to all attendees and registrants. So if you do have a question during the course of the webinar, just go to the bottom of your screen and you'll see the Q&A button. And right there, just type in your question. I'll be monitoring them throughout, and we'll try our best to answer all of your questions at the end. If we don't get to some of your questions, we will follow up with you afterwards to address the questions that you have. So let's get started. First, we're going to discuss what we're seeing in the marketplace, including with our clients. When we were sitting, preparing for this and thinking about what's transpired, we really thought about the last few years really have been a whirlwind. Thinking of the years of high demand and a lot of that from post-pandemic. And then during that time period, there was a lot of intense lateral movement. And then that was followed by a slowdown in client demand, particularly with transactions. And what we saw in a lot of our clients was any revenue growth was really due to rate increases. So now we're seeing that uptick in lateral partner movement a lot from a transactional perspective, with the expectation that M&A is going to increase. And what I think is a great thing is that firms are really now at a point where headcount is stabilized, things are kind of calming down, attrition rates are coming back to a level of a few years ago. So with the continued focus of bringing professionals back to the office leasing activity we're seeing continue at a high level. Mainly seeing it where office relocations, where firms are looking at a lower square footage in more efficient space. And I think a lot of that has to do with wanting to bring people in and making it more attractive to get everyone together. Because as we know, that's something that we've been losing over the past few years, is that being able to train people in person. So getting that new exciting space is something I think people are looking at rather than just renewing in the space that they're currently in. And one of the great parts of that is landlords are offering some amazing concessions, whether it be free rent or tenant improvement allowances. So that's really sweetening the pot and making law firms really look at this new space. So all of these things that have been going on have really provided firms with an opportunity to rethink their strategies. They're looking at their partner pool. Do they have the right people? Are we in the right practice areas? They're looking at different geographic locations. Can we expand? And then maybe with that expansion, there's complementary markets that we can also expand into with that geographic expansion. But then one thing in the midst of all this is Gen AI. It's been at the top of conversations anywhere you go, any seminars you go to. Inevitably, someone's going to mention Gen AI, also known as ChatGPT. And the one interesting thing was there was a managing partner survey over a year ago, and one quote really did stand out, and it said, Gen AI will separate successful firms from unsuccessful firms. And when you think about that, I think it rings really true, especially today, because based on some firms already using Gen AI, and then there are other firms that are kind of waiting and stepping back, and they're a little nervous and they want to wait until it's all ready to go. They don't want to really step their toes into it yet, but you'll be really late to the game just trying to catch up. So you just need to get in there, jump in, explore, and start at least planning for it now. I think then you'll reap those benefits in the future. So taking this all into consideration, we want to take the opportunity to touch on topics that directly related to all these things that are happening, but from our perspective. So looking at considerations for lateral partner movement and potential changes in partner structure, capital account considerations from a financial planning and a management perspective, state and local taxes, and considerations in this current environment, and then office space leases and related landlord allowances. One thing I do want to note, we work with partnerships, we work with corporations. As we were thinking about all these different topics, we realized partnerships have so many nuances and a lot of different things that we can really dive into. So there will be a lot of partnership-esque things throughout that we're really focusing on throughout our discussion today. So just wanted to let you know that we do have experience in both, but there will be a lot of partnership discussions today. So before we really jump into the meat of everything, Steve, could you provide a legislative update focusing on items that could impact law firms?
Yeah, sure. I mean, I kind of subtitle this as the good, the bad, and the ugly, so to speak. So Congress returned to Washington yesterday, and there's approximately 5 tax-related bills between the Senate and the House that are currently going to be considered. The one we've really been focusing on is the Senate bill, which the House had passed overwhelmingly, I think it was by a 90% approval margin back in February. And this particular bill, aside from you probably heard things like the expansion of the child credit, but really has some pro-business aspects to it, which is really restoring some of the incentives that have now been limited back to their original format, particularly bonus depreciation and the research and development expense deduction. So for those of you not familiar, bonus depreciation is sort of the removed cousin of Section 179 accelerated expensing. Mm-hmm. And bonus depreciation, if you've exceeded your limit on 179, bonus is often the fallback. Currently, bonus depreciation has been reduced from 100% to 80%, now at 60%. The legislation would provide for bonus depreciation going back retroactively to 100% deductibility. Similarly, with the R&D credit or the R&D expense, that has also changed from 100% expensing to capitalization and amortization. And basically, these reductions creates phantom income, which is the bane of almost any business. The problem we have is that right now, these two items would be restored retroactively. And retroactively means going back to 23, creating, the issues for amended returns, etc. Well, all of that would have to be processed. And that means changes in software as well as potentially changes in forms. Part of the reason this has been sitting out there so long is that we're in an election year. And there are obviously, partisan politics at play here, some of which may be getting even more out of this bill than what's currently there, notwithstanding how overwhelmingly it passed within the House. So we're hoping we're going to have an answer to this shortly, but we just don't know if this may fall into the same category of the immigration bill earlier in 23, which basically got set aside due to politics. Additionally, right now, we've got an audit situation going on. The IRS announced that they are going to be focusing on what they call large partnership audits. Large partnerships defined as those with 10 million in assets. And we're not telling you to change how your firm is operating and keep your asset level down below $10 million, but this has already started to occur. And the focal point here is really on things like marketing expenditures, business development expenditures, treatment of guaranteed payment partners, et cetera, at least at the IRS level. At the state level, the states continue to go after out-of-state firms under the market-based sourcing rules. Also, there are issues concerning remote employees creating nexus for filings. We'll talk about that a little bit later. New York City, still very aggressive in their partnership audit programs. Granted, they're basically desk audits, but seeking very similar information to the IRS, and also focusing on payments to retired partners as well. So that's it for the current situation legislatively and tax authority wise. And I'm going to turn it back over to Deb.
All right, thanks so much. And obviously we'll continue to monitor all these legislative updates and I'll let you know of any changes that you need to know about. So I think we'll get started. My first question I'll direct to Paul. So we've seen more lateral movement recently, as well as development of different classes of partners. What should firms consider when making these determinations?
Sure. Thanks, Deb and Steve. So in order to retain as well as attract talent, we've seen firms being a bit more strategic in their decision making, right? When it comes to the partner promotions, the partner level. So to keep senior associates and of counsels happy and at bay and with the firm, we've seen firms promote within these senior associates and of counsels to what's known as a non-equity partner status. So most of you may be familiar with it. What does non-equity partner mean? Outward facing, you're a partner. You're no differently than the founding partner. You're no differently than the top equity partner. Partner is on your LinkedIn page. Partner designations on your business cards. It's on your email signature. You're a partner outward facing. Inward facing may be a little bit of a different story. You may have a cap on your income, fixed or predetermined income, with the remaining profits to be shared with the equity partners, right? But outward facing, you're a partner, okay? So the non-equity status is really an internal reference. You're not going to see that anywhere designated on someone's website. So how do these non-equity partners get compensated? We've seen firms, specifically what Devin mentioned earlier, we're going to talk a lot about partnership tax, but firms that are C corporations, their shareholders or partners are compensated through a W-2, right? So nothing changes there. With partnerships, generally, when you're promoted to partner, you get what's called a K-1, right? But we've seen firms continue paying the senior associate of counsel, continue on a W-2 payment form, okay? So that kind of solidifies the fact that maybe there are a different class of partner. They may not have voting rights, okay? They're reporting their income as an employee. The benefits are their tax life is very simple, right? They're getting a W-2. Maybe they live in New York City. They work for a New York City firm. Very simple filing, right? Versus we've seen firms do the traditional method. You're going to get a K-1 now. Congratulations. You're part of the club, right? And as Steve mentioned earlier, maybe you're going to get a guaranteed payment. Very important that doesn't run through capital. We're going to discuss, Tina's going to discuss capital a little bit later. But they're going to get a K-1 psychologically for that partner. They've arrived, if you will, right? I'm getting a K-1. I've graduated from my W-2. And along with that are complexities that I'm going to talk about a little bit later. With those complexities come some planning opportunities. You can avail yourself to PTET. You may be able to get benefits for augmented pension plan deductions. So this is where we see firms treating non-equity partners, both optically and financially. And as you can see, it's not one size fits all, right? So you have to see with major decisions, with every major decision within a firm, you have to see what's best for the firm. So there's not one straight answer here.
So that was definitely very helpful. A lot of different things that firms need to consider when trying to make these decisions. So Tina, let's turn it over to you. With the new partners, whether lateral movements or in-house promotions, what are some items that firms should contemplate in that regard?
Thank you, Deb, and good morning, everyone. So I believe one of the main areas that the firm should consider is what is in your partnership agreements or shareholders agreement. As part of the work that Deb and I perform on that test side, we do review these agreements to determine whether there are certain important provisions that are in place. The agreement should have provisions that cover nuances that incoming partners need to be aware of so that it is very clear on the onset and this avoids any internal issues. So the agreement should have provisions that provide flexibility in the income allocation formula that covers pass-through entity taxes, or what we commonly call PTET, and you'll hear that a lot in the upcoming sessions or sections, and how this is allocated by partner, and this usually does not directly align with the income allocation percentages on a book basis. So we do see firms allocate income or loss before any PTET deduction based on their ownership percentages. And then the actual PTET deduction is a specific allocation and it's based on a formula. So again, this is really on a firm by firm basis. And really depends on whether the economics make sense on the individual partner. I would say also there has to be provisions that allow for holdbacks from distributions related to certain deductions and expenses that is attributed to your individual partners. Again, having these items memorialized in these agreements and adding the flexibilities that your firm sees fit allows for less confusion, because ultimately this does impact capital balances when you start applying these transactions.
All right, so those are definitely great points to consider, and it relates really to all partners. So it should be included and made clear in the agreements and made clear to incoming partners, so there is no confusion. So that was on the incoming side for the most part. What are some best practices that should be contemplated for agreements related to departing partners or that would impact departing partners?
All right, so for departing partners, I would say there should be provisions for capital repayments, and I'm not referring to any retirement payments that's on top of capital. So because you may have special arrangements for just purely retirement payments. Generally, it is best practice to have caps on capital payout. You could do it over a term, or you could do it over a limited percentage of firm income in a year, or sometimes we've seen firms do a combination of both. We do see payout term more often in partnerships, and the limitation to a percentage of income more often in corporations. But again, the firm should really determine what makes the most sense for them, right? So we have seen agreements where capital is due to the partner within 60 days, which is pretty short. It's really not ideal, because if you think about it, at the time of departure, the actual income allocation may not be known, and this impacts your ending capital balance through the date they leave. You also have to consider there's other deductions and holdbacks that also may not be known immediately that needs to be deducted from your partner's capital. So really full payout within a short period of time, that could leave your firm in a difficult position. Also, just think about, you may have situations where you may have large amounts of retirements or other outgoing partners in a relatively short period of time. So having these additional terms in your agreements is really a protection for your firm, so you have enough time to account for an accurate capital balance before you pay it out. And also think about it from a cash flow perspective, right? A firm would want to have this flexibility to manage these payouts. Again, so really important not to be tied down to a short period for capital payout, as it could be detrimental to the firm. We have seen, I would say, 4 years in many instances as a payout period, with some flexibility for earlier repayment, again, at the discretion of your management committee. So a firm can always accelerate payment if they have the capacity to do so, but it's always more advantageous to have these provisions in your agreement that provide some flexibility.
So once again, those are great points to consider. And just to make it clear, we're not attorneys, and I mean, we don't write these agreements, but this is based on our experience, based on reading these agreements, and being able to understand what are good protections for the firms. So it's never a bad time to just revisit your partnership agreements, go through and make sure that you have similar type provisions and determine if they're appropriate for your firm and whether you should add anything. So Paul, we were just talking about departing partners. I think one area where I have seen additional provisions relate to class action firms, and they have different provisions in their agreements related to departing partners relating to UBT and earnout payments. Could you just go through that a little bit and explain what that's all about?
Yeah, sure. It's probably exacerbated with class action litigation firms due to the feast or famine nature of how these firms operate, meaning they could have a case out there for 1, 2, up to 5 years, right, without settling, right? So within that time period, you may have partners that were with the firm that worked on the case, maybe even had a state claim to that case, but then that partner is no longer with the firm 3, 4, 5 years later when it settles. So what we see in these situations is we should look at the partnership agreement and have a holdback provision similar to what Tina was referring to earlier. Have something in the agreement that says, look, for any tax liabilities due to this income allocation you're going to receive. And what I mean by that is there's this UBT tax that New York City firms have to pay. It's a 4% tax. Okay, so payments to former partners is subject to this UBT tax at 4%. So a very simple example, if you're a partner and you have $1 million claim to a settlement that arises 4 years after you've left the partnership, without having something in that agreement to protect the firm, you would get that $1 million as a partner, and the firm would pay the $40,000 of tax. So we've seen where firms write in a holdback provision for these types of taxes to protect the firm. They shouldn't be shouldering this tax that normally would be borne by that partner if that partner was still there. And there are other types of taxes, maybe gross receipts tax and other ancillary business taxes that give a rise from these payments to former partners, including earnouts. It's not just limited to class action litigation firms, but we see it more profound there because of the feast or famine nature and transitionary nature of class action firms.
And that's a great consideration. I'm sure there have been instances where firms have made the full payment, went to prepare their return down the road, and then realized it's an add back and had this additional expense that had to be bore by all the current partners, and we're probably not happy at that point in time. So great consideration for firms. So everything we've talked about so far has been from the firm perspective. So let's just turn it a little bit and think about from this new partner perspective. What pains do they have, and how can firms help them when they rise to that partnership receiving at K1 level?
Right. So like I mentioned earlier, it's great to have, that accolade, that promotion to partner level. But with, with those promotions, sometimes there are pains and struggles. We really see this in two different instances. One is like the promotion from internally, right? From within, the internal promotion, that senior associate or of counsel that's been promoted. And for this discussion, let's just say they're promoted to equity partner, right? So like I mentioned earlier, they're on W-2, very simple life. The holding was paid for them, really not much to write home about. Now they're a partner, and again, we're talking about partnerships again. Now they're a partner in a partnership, they're off a W-2, they're now getting monthly draws, right? They will have a capital commitment that Tina's going to talk about in a few minutes, capital requirement to pay into the firm to capitalize their share of the firm. Where does that come from, right? Most of the time, a lot of times we see that coming from current earnings, right? So let's just say, again, that $1 million partner has a $100,000 capital commitment. I'm just for illustrative purpose. That partner is going to have $1 million of taxable income. Partner's not going to receive $1 million of cash. 100,000 of that is going to go into capital, right? On top of that, they now have to pay their own federal estimates and state estimates, where before it was all done through withholding. Now they're responsible to remit their own estimated tax payments. They have to pay their own share of FICA and Medicare now, where their employer used to pay it, right? So there's all of these little switches that get turned on once you're a partner. So the one common indicator that we see here is education, right? Educate your partners when they are promoted, when they're onboarding to the partner level. Have them speak to us, have them speak internally with finance to walk them through what the nuances of their new tax life is going to be. Okay, so that's an important part, that education, because I've had many conversations with clients that are newly minted partners, and they feel like something's wrong. They have a cash flow issue, right? They may have thought that they have more cash not as a partner. It's an education, it's a process. A lot of partners think this way, and it's a reality, right? That cash flow crunch is a reality. But if you can take that sting away from them and get in front of it, firms are much better off. There's less anxiety, there's less conversations internally. And I find that when we're involved, even though the internal finance department may be saying the same thing, when we're saying it, there's a little bit more gravitas to it. So just educate those newly minted partners. For lateral partners, it's really a function of where they come from. If they came from a corporate environment where they're getting a W-2, when I say corporations, getting a W-2, they walk across the street because they think the grass is greener. And lo and behold, that firm is a partnership. So now, like I said earlier, with a W-2, simple tax life. Now they go to a partnership that files in 12 different states, has non-resident withholding issues, has state composite issues. Maybe there's PTET. There's all these great switches that help alleviate tax filings, but it's all new to this partner. Without that onboarding process, like the internal promotion, it's anxiety driven and there's confusion. So getting in front of it is definitely the key.
Okay. So I think that, that lack of cash flow from a partner perspective can be really shocking without that proper education. And I've heard a million stories where, all of a sudden I'm making this greater amount and, then they go out and spend it and then it comes tax time and there's a huge shock right in front of them. So proper planning is definitely one of the great tools, and that additional education and coming from an outside party describing exactly what will transpire and walking through all of those different even deductions that they will have taken out of their accounts is really important to understand up front, so they'll understand what the cash flow going directly to them will be. So that being said, Tina, every partner in a partnership has a capital account, including clearly the capital contributions, undistributed earnings, and then the distributions that are paid out to them. Whereas in a corporation, each shareholder has that contributed capital. So what are you seeing in relation to capital requirements at firms and how they're being fulfilled?
So first, firms do need to establish a capital commitment for their firm, right? And they have to spread this out amongst their equity partners. The amount of capital commitment generally would depend on what type of firm you are. We talk about for a general practice firm, traditionally we see 1 to 3 months of operating expenses equating their capital requirement. Whereas if you're a class action firm, you probably see upwards of 9 months of operating expenses. It's just the nature of where your cash inflows and outflows are. Then the question is, how do you capitalize this capital commitment? Where is that funding coming from? So for partnerships, a firm can withhold from a partner's distributions over a set period of time. And for C Corp, since your partner, as Paul was mentioning earlier, you're getting a W-2, right? What we see most times is the firm withholds a certain percentage from the shareholder's payroll, and usually it's up to a predetermined cap based on various factors for that particular shareholder. Firms usually do provide for some discretion to suspend or alter these contributions at any time. You want to reinstate them anytime they have that discretion. Also, whether you are a partnership or whether you're a C Corp, you can set up a capital payment program with a bank. This was pretty popular in the past, and we've seen this put in the wayside for a while, but we've actually been seeing a resurgence on this and more firms looking into it more recently. And under this arrangement, the firm actually gets a capital up front, right? And you're not financing the capital contributions. And a lot of these agreements that we've seen, they're non-recourse to the firm, which at the end of the day also protects the firm. The debt borrowings are really mainly between your partner shareholder and the bank. So it's not with the firm itself.
Okay, so those are definitely good points to consider. So as firms are looking to manage the payout of distributions of the undistributed earnings that I mentioned before, and a lot of times these are obviously payments throughout the year. Every firm does it a little differently. Where have we seen firms caught by surprise and possibly leading to over distributions in their capital account?
Right, so there are two scenarios. I think earlier I talked about holdbacks. The first relates to accounting for all the holdbacks that may be required during the year. And the other, although similar, relates to departing partners. We've seen every firm handle distributions very differently. So some have a fixed draw amount on the monthly basis, and some could have quarterly distributions just for taxes. And then we see the bulk is paid out, at the end of the year and into the following year. I think the key is you have to have a program in place to have enough in your undistributed earnings accounts to fund for these various deductions and holdbacks. So like, just for example, medical, you have profit sharing, could be your prior year, current year profit sharing numbers, your tax payments, for composite taxes and withholdings, etc. Throughout the year before you actually pay it out directly to your partners and shareholders. Because if you think about it, certain of these deductions will not be known until the firm really files their tax returns in the following year. And if you distribute really too early, you may miss out on the opportunity, for example, to collect on the partner share of composite and withholding payments. And it's often really difficult to go back to a partner and collect it, and just much easier to withhold it at the onset, right? So when you over distribute as well, think about a departed partner, right? The risk is the remaining partners will have to absorb this departing partner's share in taxes. For example, any composite and withholding payments that your firm paid on behalf of the partners that you did not properly allocate to these departing partners, it's going to be allocated to the remaining partners, and it will be a non-deductible expense. So it's not really an ideal position to be in.
So that's a good point. I love the point on it being a non-deductible expense because no one wants to incur more non-deductible expenses, particularly if they're not their own. And I think even though it seems very simple, the points, I mean, but it's an important point to consider because, you know, once you over distribute, going back to these former partners and trying to recoup them is just a whole nother exercise, sometimes in futility. So, and now that we're approaching mid-year, it might be a good time for a little housekeeping, take a look at your program in place. How are you distributing? Are there any partners that maybe are on the brink that you really have to monitor a little more closely for the remainder of the year? So really this links to an upcoming discussion, and although PTET is a deduction and it's an expense and not a distribution, I think the way a lot of firms treat the PTET in their minds or on their, let's call it internal books, sometimes causes some issues as it relates to distribution. So can you tell a little bit about what we've seen in that regard?
So we've seen most firms do continue to track and allocate their income before any PTET deduction. So what is important at the end of the day that we have to remember is we have to account for ultimately what is the allocation of the deduction to each partner of the PTET payments that were made by your firm all throughout the year, right? So in doing so, you can accurately account for what's the allocable income net of your PTET by partner that's subject to distribution. Again, most firms do this exercise quarterly because, you know, you have to pay your PTET estimates quarterly anyway.
So on that note, let's move on to discussing state and local taxes. This topic could always be a full day or a full week seminar, but we wanted to really hone in on those items that we've been discussing with clients a lot recently, particularly in the current environment. So Paul, can you tell us a little bit about what you're seeing out there and the types of things that you're discussing with clients, I think, constantly?
Sure. And yeah, what you said is 100% correct. This topic alone could be a day or a week seminar. I don't know if people would want to sit that long talking about SALT, but it is a very, very hot topic, especially post-COVID, with remote and hybrid working now being part of everyone's reality, right? So whether it's hybrid working from home 1 to 2 days a week to the fully remote employee, it becomes an issue really for firms on 2 separate instances again. So first instance is payroll, right? Where that employee's payroll is being reported to and allocated to payroll, taxes, and unemployment insurance, okay? So regarding this item, we're going to look to see where should that payroll be withheld from. Excuse me. The second item is where firms have a state filing requirement, right? So there's payroll taxes for the employee, and then is there a firm responsibility? Is there a firm obligation based on where these employees are working? Okay, so regarding the first one, firms generally remit and pay payroll to where the employee shows up to work, where they're assigned to, right? So pre-COVID, you're working in the New York City office. Maybe you're a Connecticut resident. You come into New York. You have New York earned income, although you're a Connecticut resident, but the withholding is on New York, right? Now, hybrid environment occurs. That Connecticut resident's working from home 1 to 2 days a week, okay? But they're still reporting to the office the other 3 days a week. They're assigned to that office. Okay, so New York has this convenience of employer rule that says, yeah, great that you're working not in New York for 1 or 2 days, but our rule says the days you're working from home, it's as if you're in the New York office. Okay, so 100% of that employee's payroll is going to be allocated to New York under that methodology. Okay, I've seen questions come up where should firms be allocating between Connecticut and New York for payroll reporting purposes? And the answer is no. New York is going to challenge that, right? And they're going to win. They're going to say that's a New York employee for reporting purposes. We've seen other examples where you have a fully remote employee, right? Because we're now under we can hire anyone anywhere, right? The best talents across the nation with this hybrid working. So let's just say you hire someone in Pennsylvania that's fully remote, okay? Never going to step foot in your New York City office. It's going to sit in Pennsylvania and crank out the hours for you. That's great. I've seen firms where they allocate a New York payroll to that employee. Technically, it's a Pennsylvania payroll, right? That person is not associated with the New York City office. Okay, they are never going to step foot in the New York City office. They're remote 100%. they should have Pennsylvania withholding and unemployment insurance paid to Pennsylvania. What happens is if they file and remit payroll to New York, what's the harm? Well, Pennsylvania can come back and say, you should be paying us. You got a guy sitting here cranking out hours. We should get our fair share. But more importantly, that employee is most likely overpaying their taxes, because instead of just picking up Pennsylvania income and tax at a lower rate, they're paying taxes to New York at a higher rate and then claiming the credit over to Pennsylvania. So we see this happen. It's happening quite often, especially with the 100% remote aspect getting even more popular. So what does that mean now for the firm, right? So I'll speak to the C corporations for a second. For C corporations, every new state that you're in, and how do states tax law firms? Well, they go by a metric of nexus, right? Nexus is one of two metrics. It's your physical presence in that state, right? So i.e. an employee sitting in that state, cranking out billable hours, or there's an economic standard as well, economic metric that says, well, if you have a client located in the state and they're paying you, that's another standard for nexus. We're going to talk about physical presence. So you have someone sitting in a state, multi-states peppered across the country, that's creating additional filing requirements, okay, for the law firm. For C corporations, it's a corporate filing. It stops there. For my pass-through law firms, that entity, the partnership or the S corp, is going to pass through that income to all of its partners. So now not only do I have partnership filing, all my partners are going to be filing as well in these states. And it creates a lot of complexity. Like I mentioned earlier, all these additional states, they start to pile up. There's non-resident withholding issues, there's composite tax issues, maybe there's even PTET issues that we have to have discussions on, okay? So there are ways to ameliorate those partner filings through composite filings, right? That's a group return. They're very popular, right? So instead of filing each partner filing their own return, you see firms filing the returns on their behalf. So if you have a 50-partner partnership filing in 12 states, instead of having 600 returns filed individually, you can just file 12 returns as a group, pay the tax. Normally it's at a higher rate, it's at a flat tax, and normally you don't get certain deductions that you may be getting. Depending on what state it is, there could be an incremental cost. And as Tina mentioned before, it's a non-deductible expense, or it's charged to the partner distribution accounts, okay? But it alleviates the compliance, and that's the whole takeaway here. The takeaway is to understand the implications when you're hiring remote employees, what it means for that employee and what it also means for the firm.
So you made it clear the complexities of hiring employees in different states. What happens if you hire a partner that resides in another state?
Great. So that same physical presence is now occurring in that state, right? So even though they're not an employee, you don't have the payroll tax issue that you'd had with the employee, but you definitely have a nexus issue because now you're doing business in that state. That partner is physically present in that state. If it's a state that you don't have an office in, or a new state for you, you have to consider that you're going to have a filing obligation and determine if there's a tax due.
Okay.
Paul, just to be clear, it's not just billable employees in a state. It would theoretically be any employee, even an administrative employee who's not billing time.
Correct.
So now that we're in the SALT discussion, we can't get out of it without talking at least a little bit about PTET. So is there anything timely, anything happening soon that firms should be aware of related to PTET?
Yeah, great. So PTET, the second hottest topic under SALT, right? So unfortunately for New York State PTET, the election to opt in has passed, right? That date was March 15th, 2024, to elect into the 2024 PTET. If you did not make that election, put it on your calendar for March 15th, 2025 to elect into 2025, as that's what your firm wants to do. However, to also calendar something in the next couple of weeks is California PTET. So for those firms out there that had a California PTET filing in 23 and will continue to have a California filing for PTET in 2024, they have a payment due June 17th. Would be the 15th, but the 15th is on the weekend. So it's June 17th, you got an extra 2 days here. And that payment is the greater of 50% of last year's PTET tax or $1,000. Absent making that payment, you cannot participate in the California PTET. Okay, so it's important to put that on your calendars right now for June 17th. to determine if you're going to be participating in California PTET. For those firms that did not have a 2023 filing, take a look to see if you're going to have a filing obligation, if you want to elect into PTET for California, and you would make that $1,000 payment to preserve your right to elect in, because the election for California, the election's due with the return.
So that's great to know. With only 2 weeks to go, everyone has 2 weeks to determine whether they want to do that or not. So let's move on to, I guess, our last topic, which is leases for office space. As I mentioned before, we're seeing those movements primarily to new space. So I'll turn it over to Tina. When you're reviewing lease agreements for our clients, what are some of the key terms that you are focusing in on?
Right, so just wanted to note that this is an income tax concept. We do work with law firms that are either income tax basis or modified cash basis. I would say half of our law firm financials are probably on an income tax basis and half are on modified cash basis. And those on a modified cash basis, in the majority of instances that we've seen, do follow the income tax provisions for fixed asset related items, but some do not, and we'll talk about that later. Since we do work closely with our tax team, we are the first line of defense to identify issues surrounding these lease agreements, as we do review them as we perform our test work. And as part of our reviewing of these lease agreements, a few of the key things that we look at pertain to, whether the landlord is offering any incentives, such as free rent or build-out allowances. Sometimes it's known as tenant improvement allowances. At times as well, the allowances are phrased to include costs for furniture equipment at the lessee's option. We also look at what the term of the lease is, whether it's 15 years or under, or if it's over 15 years. The other thing we look at is renewal options, whether it's at fair market value or whether it's at a predetermined percentage of the prior year.
So then when you're looking at the leases, you make these determinations and you call out these different terms. What happens? What does it mean if the term is 15 years and under or over 15 years, or if it's the renewals are at fair market value or a discounted rate? What does all that mean?
So determining what the lease term is under these rules determines how you account for the build-out allowances, right? So if the lease agreement is 15 years and under and contains a renewal option based on fair market value, then you exclude that option from the calculation of the lease term for safe harbor purposes. If the rental payments under the renewal option is at a discounted rate, or it's just at a similar rental payments as your existing lease, then you include that renewal option in the calculation of the lease term. So then now you determine what your lease term is, right? So if your lease term is 15 years or under, it's considered a short-term lease. What does this mean? Any amounts that you receive in cash or you treat as a rent reduction and use for your leasehold improvements, these are not treated as income to the law firm. The improvements are paid by your landlord. They're owned by your landlord. So technically, they're not property of your firm. So your leasehold improvements are not recorded on your books. And therefore, you don't have to consider a depreciation, right? Conversely, if your lease term is over 15 years, that's considered long-term. Therefore, it does not meet the safe harbor provisions. And what does this mean? Any amounts that you receive as rent reduction or receive in cash as reimbursement is considered income to the law firm. Then you would have to capitalize those leasehold improvements on your books. You depreciate them accordingly. Right now, it's 15 years for tax purposes, or you can avail of accelerated depreciation methodologies. Again, this could still result in net taxable income, as you may not be able to accelerate 100% of that depreciation. So looking in this scenario, I just want to point out that you may potentially have a timing difference of when you're picking up the fixed asset in your books and the reimbursement, since there could be a year where you're capitalizing the fixed asset in, let's say, 24, and you don't get the reimbursement until 2025. So you could have an expense hitting 1 year and the income hitting the following year.
So it seems like we're very advantageous. Oh, go ahead, Steve, you want to?
Yeah, so Tina, to be clear, if you're over the 15 years, you're just outside of the safe harbor provision, but you can negotiate, and depending upon the common law test, you could still exclude that reimbursement from income, but that lease has to really belt and suspender that that's what the intention of the parties are, so the firm doesn't have immediate income with regard to that tenant allowance.
Right. So that's a super important point that we were going to get to, that You don't want to have to deal with all these timing issues and have to deal with if I have income one year and I'm not going to be able to offset it by a corresponding expense. So to be able to belt and suspender the agreement, and that's why it's super important to bring us into the process. We can point out these things to you and help you along the way. So one other thing, Tina, what does a firm need to be cognizant of if you mentioned that we also work on modified cash financial statements? And although most of the time we do see them file income taxes for many provisions, including depreciation, what happens if they do not?
Right. So if the firm accounts for depreciation for books very differently from tax, you have to figure out how the methodology differs, right? So if the firm accelerates depreciation for tax and takes it all or probably a good portion of it in year one, but for books they amortize it over the lease term, then technically your capital balance on the books is higher for tax, right? So if a partner departs, they're usually paid out on book capital. So if the departed partner would have benefited already on the tax deduction and have a lower capital, but he's still being paid out in cash on the higher book capital. So technically other partners lose out on the tax deduction. So in this instance, really careful tax planning is very important. You should really consider it when your firm is contemplating significant capital expenditures at any time. I should also want to point out that, you should be aware of any bank covenants and impact that this transaction could have on your book number or your bottom line, because these are non-cash transactions, right? That you may not be thinking about at the end of the year, but it definitely does impact your bottom lines. And just be aware of any provisions as well in your bank agreements, if there's any limits on any CapEx.
And I think there's one other thing when you're looking at your bank covenants. Some have limitations on your unfinanced CapEx expenditures in a particular year. I see that in a lot of agreements. And also to note that if you're going to purchase furniture fixtures or any other types of things and utilize some type of financing, and it's with a different bank possibly than the bank you're currently with, or some other type of financing company, many bank agreements indicate that restrictions on borrowings from other parties. So just something to consider, that if that is something you're contemplating, that you get that waiver from your bank before you go out and do that. So, all right, I think that wraps up the discussion on leases, and we're exactly on time with 10 minutes to go for questions. We did have a few come in, and one that catches my eye right now actually is right on topic with the lease discussion. So we'll just go over to that one. Paul, I think maybe you could take this. The question is, we talked about the landlord allowances and we're talking about leasehold improvements. And Tina, I know earlier discussed that some provisions in the agreements indicate that the allowances could be utilized for furniture and fixtures. Could you just address whether or not you pick up that reimbursement in income or not, or how does that work around the whole safe harbor rules?
Okay, so for the safe harbor rules are specifically designed around qualified long-term property, qualified leasehold improvements under that 15-year or under lease term. Any other property falls out of the safe harbor, right? So if you fall out of safe harbor, Steve had astutely mentioned earlier, there is a way for leasehold improvements to be wordsmith into the agreement that title retains with the lessor, with the landlord. That will help you alleviate picking up the taxable income component of that tenant improvement allowance. On the non-long-term property, the furniture and fixtures, the shorter term lives, really don't see that as much as being worked into an agreement that the ownership is going to retain with the landlord, because logistically the landlord's not going to want to own computers or desks or chairs. They do want to own the walls of the leasehold improvement because it's part of their building, right? So the lease term doesn't qualify there. So that would be an income pickup if it's in the agreement that the landlord's paying for it. It's going to be an income pickup, and as Tina mentioned, then you get to depreciate it. Maybe you have accelerated depreciation, but there most likely could be like an income pickup that then gets exacerbated based on where your partners are terminating or new partners down the road that are going to getting the depreciation deductions.
Right. But Paul, that's if it's done as a reimbursement, right? Like a tenant allowance type of situation.
Mm-hmm.
You can structure it where the landlord is providing, in effect, furnished space,
Mhm.
desks, etc., so that at least that way it is the landlord property, right? As opposed to the tenant property that they're being reimbursed for. And
Correct. And
that, yeah.
Correct. And the whole takeaway is a lot of times the leases are being scrutinized by the test team during field work. The takeaway here is please get us involved earlier in the stage, get a draft lease agreement over to us so we can identify these items, and because there's more than one way to skin that cat.
Right, and it's just a turn of any words can really make a big difference in those lease agreements. Okay, so we did have, let's see, one other question here. This goes back to our discussion related to hiring hybrid employees that are in another state. And the question is, what happens if you find that a new hire you made earlier this year has been categorized in the wrong state? What do you do?
Oh, so right now it's June. So if someone's looking and saying, oh, we have a new hire January 1st, 2024, and we've miscategorized them, right? We were doing that Connecticut, I'm assuming that's where the question is coming from, Connecticut 2/5, New York 3/5, and they file payroll tax returns. It's much easier in the current year to ameliorate that. You can file amended payroll tax returns now, right? Because what happens is if it happens after the fact, it becomes quite an onion that needs to be unraveled, and it's very challenging and cumbersome once W-2s are issued. So it's very important right now. That's why we're having the seminar in June. Check under the hood now, see where your new employees are, right? Where you're categorizing them. One thing I meant to mention earlier regarding this concept, funny how the question came up, is sometimes employees give addresses that may not be where they're working out of. It may be a convenient address for mail, or just an address that they don't want their employer to know where they're actually living. Whatever it is, make sure that the address that you have is the address where that employee is physically working out of. I have had situations where the addresses weren't exactly correct, and it created additional taxes. So know that. But to answer that question, you can file amended payroll tax returns during the current year. Much easier to catch it now than it is after the year end.
Okay. Then we have a question. It says, it appears by adding employees in other states will potentially require adding more state filing requirements, which would create more, will that create more compliance for those underlying partners then?
Yeah, so the question is, so the more states that we're in, right, the more the firm for a partnership and an S corporation could create additional tax filings for the partners. As I mentioned earlier, the firms can file, if states have them, and most states do, composite returns that will alleviate the obligation for the individual to file, the individual partner file. You have to meet certain criteria. You have to elect in. So most of these, there's a formal election process, whether it's housed internally or a box checked on a form. But yes, the answer is it will create additional filings, but there are ways around having each individual partner having to file through the composite returns, through those group returns.
Are there negatives to the composite returns at all?
Yeah, the negatives are sometimes, like California, for example, you're quickly rising to the top rate, right? You're not getting the benefit of graduated rates that the individual would get, and you may be losing out on certain deductions. Okay, every state's different. Most states are going to make it a little bit more cost prohibitive because there's some pay dirt for them there, and it's ease of complexity. Like I mentioned earlier, 50 partner firm. Well, if you can alleviate 50 individual filings, for that partner, it's better for them as well, right? So maybe the incremental cost makes sense. You have to, again, get us involved, but see where that incremental cost, where it is. If it's a couple $100, I don't think anyone cares, but it can grow into the tens of thousands. Then it becomes a different animal.
Okay. So I think we've come to the end of our time with you this morning. If we did not get to your question, we'll touch base soon to address it. We really do appreciate you taking the time early this morning to spend some time with us and hopefully have some takeaways. I think we touched on a variety of topics, and we hope that if you have any questions, you'll come back to us and we'd be more than happy to discuss them with you or talk to you about those items. But we hope you have some items now to bring back to your firm and contemplate and maybe possibly even put into practice. So just as a reminder, this webinar was recorded. It will be distributed via email to all attendees and registrants. And we'll also include our contact information in that email so that you can contact us at any time with any questions. Once again, we appreciate it and thank you and have a great day.